Donald Trump's orders to put the Consumer Finance Protection Bureau out of business has met a hard place. And her name is Judge Amy Berman Jackson, a D.C. federal district judge who in a 120-page decision has entered her order to stop Donald Trump from putting this congressionally created Consumer Protection Bureau, which is the only oversight over banks and their relationship with consumers, out of business. That bureau was created in a bipartisan moment in 2010, following the 2008-2009 financial crisis that made $10 trillion with a T dollars of American and consumer wealth disappear because of the subprime mortgage loan crisis. And it was the counterweight to the government bailing out the banks. This is all through Obama to save the economy, as we know, bailing out the auto industry. Who was going to bail out the consumer? And so Congress created, and Trump, according to Amy Berman Jackson, is violating what we refer to now as the Dodd-Frank Act, which is also known as the Wall Street Reform and Consumer Protection Act. Remember when those two things went together? Regulating Wall Street, protecting the consumer? Well, Donald Trump doesn't like the sound of any of that. So he attempted to take through Russ Vought, the head of the Office of Management and Budget, take the Consumer Finance Protection Bureau, take it in the back and shoot it. Remember, at one time, Senator Warren was the head of the CFPB. Let me read to you from the order itself so you understand why this is so important. And then I'll go over a really great and succinct analysis of the separation of powers and why and many federal judges in over 150 cases filed are watching and trying to stop an out-of-control president who only thinks the Constitution consists of Article 2 and Article 2 powers, often rejecting the existence of Article 1, which has to do with the power of Congress. Here's how Amy Berman Jackson, who I think is shortlisted and should be shortlisted for the United States Supreme Court when the Democrats get the presidency back. Remember Amy Berman Jackson. Here's how she started. Memorandum opinion. CFPB, the acronym or initials for the Bureau, RIP, Elon Musk, February 7th, 2025, social media post. Next day, February 8th. This is the start of her opinion. The CFPB has been a woke and weaponized agency against disfavored industries and individuals for a long time. Banks and lenders and predatory lenders against American voters. Yeah. This must end. Russ Vought, February 8th, 2025. He's the architect of Project 2025. He is your director of the Office of Management and Budget under Trump. That third quote, that was a very important thing to get rid of. President Donald Trump, February 10th, 2025. The motion, this is first page. The motion for preliminary injunction to be decided boils down to one question, the judge wrote. Should the court take action to preserve the Consumer Financial Protection Bureau now, before the case concerning its fate has been resolved? This is an extraordinary step, she wrote, and before it can step in, the court must conclude that the plaintiffs are likely to succeed on their claims, that they would suffer irreparable harm in the meantime if the court lets the lawsuit run its course, and that an injunction would be in the public interest. Second page, the court has made those findings, and the answer is an overwhelming yes. The court can and must act. You're watching bravery. You're watching independent judges do their thing in support of the Article 3 powers that they hold to keep the Article 2 powers of an out-of-control president in check. She continues. The evidence presented in connection with the motion, the testimony of the agency's chief operating officer and other witnesses showed that Russell Vought, the acting director of the CFPB. Oh, did I mention he's the head of the Office of Management and Budget, but Donald Trump put him in, Russell Vought, the architect of Project 2025, as the acting director of the Consumer Finance Protection Bureau? This is promoting the wolf inside of the chicken coop. He just got a job promotion. As of that date, the defendants were fully engaged in a hurried effort to dismantle and disable the agency entirely, firing all probationary and term-limited employees without cause, cutting off funding, terminating contracts, closing offices, all offices. These actions were taken in complete disregard for the decision Congress made 15 years ago, which was spurred by the devastating financial crisis of 2008 and is embodied in the United States Code, the law, the statute, the one that Trump has to take care to faithfully execute. That the agency must exist and it must perform specific functions to protect the borrowing public. Remember, all those trillions of dollars were being spent to bail out Big Auto, to bail out Big Bank. Who was protecting the consumer from the predatory practices in the subprime mortgage loan debt? They were stuck with those loans. Some, but not all, consumers got stuck with these subprime mortgages at ridiculous escalated rates. Who was going to protect them? The answer came from Congress. That's what Trump wants to get rid of now in favor of the banks. She continues on page 3. This is precisely the sort of situation preliminary injunctions were designed to address. If the defendants were not enjoined, the Trump administration, they will eliminate the agency before the court has the opportunity to decide whether the law permits them to do so. And as defendants' own witnesses warned, the harm will be irreparable. She goes on, talk about the creation of the CFPB, why it happened, the context of it. She also said on page 5, as a result of the consolidation of certain functions, that bureau is the only federal agency authorized to supervise the nation's largest banks for their compliance with consumer financial protection laws. Don't we all think that protecting the consumer and consumer protection is a good thing? You ever been ripped off by a used car or a car dealership? Don't you want to have consumer protection around that? When you make your big purchase in life, if you're lucky enough to buy a house, to buy a car, to invest somehow, don't you want to have your investment and yourself protected from the sharks, from the predators, from the billionaires and oligarchs that are all in Donald Trump's administration? Don't you want that? Sounds like a good thing, right? It's not stopping people from making money, obviously. The court continued. The Bureau, provides non-banks of all sizes in certain market segments like mortgage companies. Oh, there's a group that doesn't need to be regulated. Mortgage brokers and mortgage companies and payday lenders. Oh, there we go. The people that are preying on other people who don't have enough money check to check. So they give them a loan between the checks at exorbitant interest rates. So sounds like somebody you'd want to regulate. Credit reporting agencies. Our entire life is based on your credit score. Digital payment apps and debt collectors all come under Consumer Financial Protection Bureau. It is, and she gives a statistic on page 5. To date, the Bureau has returned more than $21 billion improperly taken from 205 million consumers, in addition to $5 billion in civil penalties when businesses took their money are insolvent. That sounds like a good thing. She then goes through, obviously taken from the record, pages and pages and pages of evidence, emails from Russ Vought, emails from others. Here's one in particular. This sums it all up. As of February the 8th, Russ Vought, it's on page 12, reproduced on page 12. This is a great way to wake up on a Saturday morning if you're working over there. 8:50 a.m. to all employees. Dear colleagues. Oh, I love the way this starts. This is the wolf gathering the chickens around and calling them colleagues. Dear colleagues, I am honored that President Trump designated me as acting director of the Bureau. I'm committed to implementing the president's policies, not Congress's intent for the branch. I'm committed to implementing the president's policies consistent with the law and acting as a faithful steward of the Bureau's resources. Effective immediately, personnel of the Bureau shall not approve or issue any proposed or final rules or formal or informal guidance. Stop working. They shall Suspend the effective dates of all final rules. They shall not commence, take additional investigative activities related to, or settle enforcement actions. Stop your work regulating for the protection of consumers. They shall not open any new investigations. You're out of business. Go fishing. They shall not issue public communications of any type. Gag yourself. They shall not approve or execute any material agreements. Stop contracting. They shall not make or approve filings or appearances by the Bureau in any litigation. Default in all your cases. They shall cease all supervision and examination activity. The thing that Congress told you to do, that they statutorily mandated for you to do, stop doing it. And cease all stakeholder engagement. Stop talking to other people. Does that sound like they're faithfully executing the laws Congress has established and the funding that Congress has established? The judge goes on, and she roasts Trump, which I love, about Article 1. She says, Article 2 is oft-cited by the president as his power, right? Article 2 powers of the president. They think they're unlimited. They can't be reviewed. Of course, the judge goes through a whole analysis how judicial review is the bedrock of our country, of our jurisdictional and constitutional order. But then she says, but Article 2 presupposes that there's an Article 1. And let's take a look at Article 1. And Article 1 gives the power of the purse to Congress, gives the power to create law to Congress, not to the president. The president doesn't create law despite executive orders. He's supposed to faithfully execute and take care to execute the laws created by Congress. That is the constitutional order of things. And that's the part that the judge is most upset about. So she has, let me just give you her final conclusion here, and I'll tell you what happens next. Page 112. In sum, the court cannot look away, or the Bureau will be dissolved and dismantled completely in approximately 30 days, well before this lawsuit has reached its conclusion. Therefore, she grants plaintiff's motion and issues a preliminary injunction. So this isn't even a temporary restraining order. We're one step up from there. Preliminary injunction that maintains the agency's existence until this case has been resolved on the merits, and orders it to preserve the agency's contracts, workforce data, and operational capacity, and protect and facilitate the employee's ability to do their job. The court is aware. Now, there's a little bit of a debate going on about the order. She's about to issue an order. I'll do another update on that. But this is her memorandum opinion. That there's two parts usually, sometimes, to a federal judge's decision-making. Just do a quick breakout there. They can make a decision in court, an oral pronouncement from the bench, ruling from the bench. I am ready to rule, then they announce. They can then memorialize that in a minute order. The minute order ends up on the docket so that the electronic docket is there for the public to see, and they have a clear idea of what has happened in our public, because the public has a seat at the table in our justice system. We do things in the open transparently. We don't do things with star chambers in the dark. Then you start with a temporary restraining order. The judge will put the grounds for it in the order. Sometimes you have an opinion, and then the order is a second document. Sometimes they combine the documents. Same thing for preliminary injunction. They can put, she could have done memorandum, opinion, and an order, but she decided, let me get the opinion out. Let me block and enjoin the Trump administration. And then she turned it over to the parties to try to work out an order. It's always better to have both parties agree to the order or work on the order for appeal purposes. It's hard to appeal when you've worked on the order. Got it? So the judge says, the Trump administration, DOJ, you work on the order with the other side, right? And come back to me with a proposed order, or if you can't agree, I'll make the final decision. So that process is going on right now. But again, sometimes it's all unitary in one document. All right, we're at the end. Good news, Consumer Finance Protection Bureau, which everybody in Congress at the right amount, at the right time, in the right context wanted and needed. We need to protect us as consumers, right? We don't want to let down the guard and have the government just turn over the keys to our affairs, our public affairs, our financial affairs, to big banks, predatory lenders, payday lenders, auto loan companies, auto dealerships. Think of the world. What a Hobbesian world we will live in. Forget Darwin. This will just be Hobbes. In any event, I'm Michael Popok. I'll continue to cover it right here on Legal AF. Take a moment, boom, hit the subscribe button and help us continue to grow this pro-democracy channel. So until my next reporting, it's Michael Popok. In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.